As that last one. Jesus. Hello, everybody. This is Empowering Democracy. It's another Dump the Corrupt show. And tonight we're going to talk about the Center for Constitutional Rights suit, on Gaza in court and what happened there in more detail. We're also going to talk about important cases in the Pennsylvania and Oregon state Supreme Courts. And lastly, we're going to talk through an article written by Bob Reich talking about the possibility of a certification disaster relating to the 2024 presidential elections, which could very well fail of certification due to bad faith on the part of the Republicans. But let us begin with the first of our articles on the Center for Constitutional Rights case. So I'm going to present that now. This is a piece from Marjorie Cohn at Truth Out. It's a great piece. The headline is, U.S. judge admits horror of Gaza, the Gaza genocide, but will he dismiss the case against Joe Biden? Of course, he has dismissed it by now. This article was written on January 31st. It's already February 2nd, and a decision was handed down. The judge noted that the U.S. government doesn't dispute the uncontradicted evidence of a, quote, genocide in progress, unquote. Again, this is by Marjorie Cohn of Truth Out, January 31st, 2024. There's a picture of Joe Biden with half of his face, the lower half, shaded from the sun, most probably by a tree. It's a picture of him answering questions while departing the White House on January 30th, 2024, Washington, D.C. The picture is by Wynn McNamee, and it's from Getty Images. This is part of the series, Human Rights and Global Wrongs. That's the article. Mere hours after the International Court of Justice found a plausible case that Israel is committing genocide in Gaza, a historic hearing took place in a federal courtroom in Oakland, California. Several Palestinians who were suing President Joe Biden, Secretary of State Antony Blinken, and Defense Secretary Lloyd Austin for failure to prevent the genocide and complicity in genocide testified before District Court Judge Jeffrey White in a live-streamed session. Quote, I've lost everything in this war, plaintiff Dr. Omar al-Najjar testified from a hospital in Gaza. Quote again, I have nothing but my grief. This is what Israel and its supporters have done to us, unquote. Al-Najjar reported the conditions are so bad, there is, quote, widespread childbirth in the street, unquote. Center for Constitutional Rights, CCR, filed the lawsuit in the United States District Court of Northern California on November 13th, 2023, on behalf of Palestinian human rights organizations, Defense for Children International Palestine, DCI-P, and Al-Haq. Three Palestinian individuals who live in Gaza and 5 Palestinian Americans who have family in Gaza. The complaint in Defense for Children International Palestine versus Biden alleges violations of the Genocide Convention and customary international law which forbids genocide. On November 16th, plaintiffs filed a motion for a preliminary injunction to immediately force Biden, Blinken, and Austin to stop providing additional money, weapons, and military and diplomatic support to Israel for its genocide in Gaza. In the January 26, 2024 hearing, featured testimony by Palestinian plaintiffs and a renowned expert on genocide and the Holocaust. The plaintiffs testified from Gaza, Ramallah, and in the courtroom. They described the death, devastation, and displacement their families have suffered since Israel began its military assault on Gaza after the October 7th attacks. Attorneys representing the Department of Justice did not challenge the fact that Israel is committing genocide or contest the plaintiffs' allegations that U.S. support has furthered the genocide. They argued instead that the court doesn't have jurisdiction to hear the case because it involves a political question regarding foreign policy that is reserved to Congress or the president. The political question is in quotes. Judge White appeared very sympathetic to the Palestinian plaintiffs, but he signaled that he may find that the issues in dispute raise a political question, which would prevent his court from hearing the case. It is rare that a federal judge allows a hearing to be broadcast. It attests to the public interest in charging the president and 2 cabinet members with complicity in genocide and failure to prevent genocide. The judge approved licenses for 1,000 people to watch the proceedings via Zoom, and even that didn't cover all of those who wanted to tune in. Quote, the Gaza that we knew no longer exists, unquote. The witnesses, including Ahmed Abofoul, a Palestinian lawyer and legal researcher at Al-Haq, one of the organizational plaintiffs who testified more than 60 relatives on his father's side had been killed, 15 of them in a single airstrike. Many of their bodies remain buried under the rubble. For the first time in its 45-year history, Al-Haq is unable to document human rights violations throughout Gaza. Quote, the Gaza that we knew no longer exists, he said. Plaintiff Layla El-Haddad, a Palestinian-American writer, testified that her neighborhood in Gaza was reduced to, quote, a large pile of sand. Dozens of her relatives have been killed in Israel's assaults, and some were buried in mass graves. She described a, quote, profound feeling of not just sorrow and sadness, but injustice and helplessness, unquote, adding, quote, Biden could, with one phone call, put an end to this. He's decided to aid and abet, unquote. And plaintiff Wael El Hassi is a Palestinian American with extended family in Gaza. More than 100 of his relatives have been killed or injured since October 7th. Quote, Israel is making Gaza unlivable, so there will be nothing for them to come back to. People don't want to leave. If they stay, they might die. If they leave, they won't be able to come back, unquote. Um, 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 the, the plaintiff, Basim El-Qada, who is a Palestinian American, testified that after the temporary humanitarian pause between Israel and Hamas in November, 65 members of his families were murdered by Israeli forces. Dozens are missing. Quote, how can children or anyone deal with relentless bombing that shakes you to the core, unquote, he asked. Um, Khaled Kuzmar, General Director of Defense for Children International Palestine, an organizational plaintiff, testified that DCI-P provides legal services and psychosocial support to children. It monitors and documents human rights violations against Palestinian children. Now, he said, DCI-P is, quote, completely unable to work, unquote. Department of Justice attorneys objected to the testimony of Barry Trachtenberg, a professor of Jewish history and expert in genocide and the Holocaust, saying he was not qualified to opine on matters of law, but the judge allowed it. Trachtenberg said, quote, Israel's assault on Gaza has been funded by the American people, fought with U.S. supplied weapons, and encouraged by a complicit White House. Unlike past genocides, which were adjudicated long after they had concluded, we have an opportunity to halt this one in its tracks. Palestinians have suffered far too much and for far too long, unquote. The lawsuit charges Biden, Blinken, and Austin with arming Israel's genocide. The lawsuit alleges that Biden, Blinken, and Austin transferred weapons and military equipment to Israel during its unfolding genocide. The defendants have asked Congress to appropriate $14.1 billion in military assistance to Israel, in addition to the $3.8 billion the U.S. already provides to Israel each year. Anthony Blinken authorized a $320 million transfer of military equipment to an Israeli manufacturer of precision bomb kits. As Israel's closest ally and strongest supporter, this is in quotes, being its biggest provider of military assistance by a large margin, and with Israel being the largest cumulative recipient of U.S. foreign assistance since World War II, the United States has the means available to have a deterrent effect on Israeli officials now pursuing genocidal acts against the Palestinian people in Gaza. The legal complaint states Palestinian plaintiffs are asking the court to declare that defendants Biden, Blinken, and Austin violated their duty under customary international law as part of federal common law to take all measures within their power to prevent Israel from committing genocidal acts against the Palestinian people in Gaza. Plaintiffs also seek an injunction ordering the defendants take all measures within their power to prevent Israel from committing genocidal acts against the Palestinians in Gaza. This includes ordering defendants to exert influence over Israel to one, end its bombing of the Palestinian people in Gaza, which has caused mass killing and serious injury. 2, lift the siege on Gaza and allow all fuel, food, electricity, water, and humanitarian aid into Gaza. And 3, prevent the, quote, evacuation or forcible transfer and expulsion of Palestinians from Gaza and guarantee their freedom of movement. Finally, plaintiffs are asking the court to issue an injunction to prohibit defendants from 1, providing, coordinating, or facilitating military assistance and money to Israel, including the sales, transfer, and also delivery of weapons to Israel, and the provision of military personnel and equipment that advance Israel's commission of genocidal acts, and 2, obstructing attempts by the international community, including the UN, to implement a ceasefire and lift the siege on Gaza. Will the judge find that the case raises a, quote, political question, unquote, and dismiss it? Judge White began the hearing by noting the brutal attacks by Hamas and that Israel's defensive campaign was similarly brutal. He noted that Israel had killed tens of Palestinians, children, and the destruction was widespread. Israel, the judge said, quote, destroyed critical civilian infrastructure, schools, also refugee camps and safe houses, unquote. He described the U.S. as, quote, substantial military, financial, and diplomatic support, unquote, and said it continues to, quote, fund and prefer weapons, unquote, to Israel. The judge then asked counsel for the plaintiffs and defendants whether the court, judicial branch, had jurisdiction to hear the case, or whether it involved foreign policy decisions that were, quote, quintessential political questions reserved to the executive and legislative political branches. CCR attorney Catherine Gallagher, representing the plaintiffs, told Judge White, this is not a political question, it's a legal question. These are not questions of policy, quote unquote, she said. Quote again, these are questions of law, unquote. The courts serve as a check on the political branches, she said. The executive has, quote, no discretion to violate the law, unquote. And the United States has a, quote, clear, ambiguous duty to punish and prevent genocide, unquote. The U.S., she added, is making policy determinations that are contrary to international law. I must add here, which I think that attorney Gallagher is quoted later on also, but in case she's not, I want to make the point here that the United States is a signatory to the Genocide Convention. So is Israel, okay, a signatory. But the Genocide Convention is a treaty signed by the United States. And treaties are the law of the land here. And they trump also ordinary domestic law. The only thing they do not trump is the Constitution of the United States. And the Treaty on Genocide is not contrary to the Constitution of the United States. It does not conflict with it. So the point is, it's not only that we're violating international law. According to our own Constitution, we are violating domestic law. What is now domestic law? I want to make that clear. Now I go back to the article. Attorney Jean Lynn argued for the DOJ that it is, quote, not the role of the courts to indict Israel for violation of international law. And she's right about that. However, in this case, the international law was also the domestic law because we had signed a treaty. Anyway, going on with the article, she said the plaintiffs were directly challenging U.S. policy, unquote. Yes, because the U.S. policy was in violation of domestic law. The Congress, okay, and the president, okay, especially the president, doesn't have the authority to violate the domestic law of the United States. I'm saying that now, that's not from the article. Judge White cited a 2017 case in which his own decision to dismiss was affirmed by the Ninth U.S. Circuit Court of Appeals. The Marshall Islands had sued the United States to fulfill its legal obligations under the Nuclear Non-Proliferation Treaty and customary international law to negotiate in good faith to end the nuclear arms race at an early date and for total nuclear disarmament. Judge White said the case involved non-justiciable political questions. Gallagher distinguished that case from the present case. In the Marshall Islands case, the plaintiffs were seeking to compel negotiations. But here she said there is a legal question whether the defendants failed to prevent genocide. Quote, it's fundamentally different than weighing into negotiations, unquote. I think she's right about that. Okay. She cited the ICJ's new decision that makes clear there's an obligation to prevent, and punish genocide. There's an obligation under international law, but there's also an obligation because the U.S. is a signatory. There's also an obligation under domestic law because international law becomes domestic law when we have signed up to a treaty that specifically promulgates international law, like the Genocide Treaty. Again, that's me. Judge White also asked plaintiff's counsel what an injunction would look like if he issued one. Gallagher responded, quote, there can't be more military support to the ongoing genocide in Gaza, unquote. She clarified that the plaintiffs aren't seeking to end all military support. For example, Israel's Iron Dome anti-missile system would not be implicated. Also, what's it called again? The Iron Beam. Yeah, Israel's Iron Beam also would not be implicated. She proposed a hearing with the U.S. government and discovery to examine which weapons Israel is using in Gaza. It hasn't been using the Iron Beam, in Gaza. It's been using tanks and airplanes and guns and artillery. Lynn said the court has, quote, no jurisdiction to enjoin the president in his official duties, unquote, as commander-in-chief. The judge cited the supremacy clause of the Constitution that says treaties are the supreme law of the land. That includes the Genocide Convention. Exactly what I said. Lynn retorted that even if the genocide is the supreme law of the land, that doesn't mean it may be enforced by U.S. courts. Well, that's true, but only in the sense that the courts don't enforce anything. The executive branch enforces things, the police enforce things, the FBI enforces things. The courts don't really enforce things. What they do is they find whether particular people have violated, the law, or whether politicians have violated, the law. They deal with violations of the law and they deal with interpretations of the law. They do not deal with enforcement. That is an executive function. On the other hand, the courts can order the executive branches, state and local and federal, to enforce the supreme law of the land. Courts have the authority to do that. That is the role of courts. I'm sorry, I departed from the article again. Gallagher noted that genocide also violates customary international law, which arises from the general and consistent practices of states. customary international law is part of federal common law and must be enforced in U.S. courts, whether or not its provisions are enshrined in a ratified treaty. But I have to add, in this case, they are enshrined in a ratified treaty also. So, federal common law and ratified treaty both say that there is a violation here, that there's a violation of the law, of laws, a violation of the highest crime, which is genocide. Judge White characterized the testimony as, quote, truly horrific, gun-wrenching, no words to describe it, unquote. He noted the government doesn't dispute the uncontradicted evidence of a, quote, genocide in progress, unquote. Quote again, the Palestinian people are living in fear without food, medical care, clean water, or sufficient humanitarian aid. Defendants, the President of the United States and his Secretaries of State and Defense have provided substantial military, financial, and diplomatic support to Israel, unquote, Judge White said. Quote, however, the primary concern for this court is a limitation of its own jurisdictional reach, unquote. He said this case was one of the, quote, the most difficult, unquote, of his career. He told the plaintiffs, you have been seen. You have been heard by this court. I'm going to take it extremely seriously, unquote. Judge White may decide to play both ends against the middle, says Marjorie Cohn. His decision could begin with a detailed recitation of the horrific facts on the ground in Gaza, the weaponry that the U.S. provides to Israel to kill large numbers of Palestinians, and his sympathy for the suffering of the plaintiffs. He will say what a difficult decision this is for him, but my hands are tied, he might say, because this case raises, quote, non-justiciable political questions, unquote, reserved only to the executive and legislative branches of government, so he must dismiss the case. Or he may take the high road and allow these Palestinian plaintiffs redress for the unspeakable violence perpetrated against their families and organizations by Israel and allow them a judicial remedy. Gallagher reported that a massive crowd of supporters convened outside Judge White's courtroom as a huge sign reading, quote, stop the genocide, Biden, hung from the federal courthouse. Activists around the country are also demonstrating in support of the genocide lawsuits against Israel. On January 26th, the day of the hearing in the Oakland case and the issuance of the ICJ's order, on provisional measures, hundreds of Palestinians, Jews, and other local community members gathered in downtown Portland for a march and a rally calling for an immediate ceasefire in Gaza and an end to military aid, an end to U.S. military aid to Israel. The action was endorsed by several civil society groups, including Jewish Voice for Peace, PDX, and Healthcare Workers for Palestine, Portland. Cities throughout the United States have been passing resolutions calling for a ceasefire in Gaza. Regardless of how Judge White rules in the Palestinians' case, it represents a milestone in the struggle to stop Israel's genocide in Gaza. It will inspire people in the U.S. and around the world to demand an end to Israel's oppression of the Palestinian people. Update. On January 31st, Judge White reluctantly dismissed the Palestinian plaintiffs' lawsuit against Biden, Blinken, and Austin. Relying on the political question doctrine, the judge found he had no jurisdiction to hear the case. He wrote that, quote, the ongoing military siege in Gaza is intended to eradicate a whole people and therefore plausibly falls within the international prohibition against genocide, unquote. But he concluded this case was a, quote, rare instance where the, quote, again, the preferred outcome is inaccessible to the court, unquote. He also wrote that the court implores defendants to examine their results of their unflagging support of the military siege against the Palestinians, in Gaza, unquote. So that decision, in its substantive content, was certainly a repudiation of what the administration is doing. But I have to say that I think the judge was mistaken in applying the political question doctrine to this case. I think that Attorney Gallagher was right in pointing out that the Genocide Convention is the supreme law, of the land. And there seems to be no reason why citizens within the United States cannot call on the judicial system to find that the President of the United States, and his advisors are obligated to enforce the supreme law of the land. This is not the courts enforcing the supreme law, of the land. That's a semantic confusion. It's the courts ordering the executive branch of government to enforce what everybody agrees is the supreme law, of the land. If courts cannot do that, then what can they do if the executive branch violates the law? Surely, when the executive branch violates domestic law, the courts have a right to say so and to find that the executive branch is mandated to follow the law. If this had been a domestic law case and not, a foreign policy case, and the president had done something illegal, or let's say the Secretary of State had done something, that was illegal. Let's say the Secretary of State had broken the law by murdering someone. Certainly, the courts of the United States would have jurisdiction to try and penalize the Secretary of State, of the United States. And you may say, well, if he murders someone on U.S. soil, then that's not, an international law question. But of course, treaty law is the domestic law, of the United States. So, in supporting the violation of the Genocide Convention by Israel, the President, the Secretary of State, and the Secretary of Defense have all violated the domestic law, of the United States. It seems to me the court does have jurisdiction. The argument I just gave is an argument for jurisdiction. If I were in Judge White's position, I would have ruled for the plaintiffs in this case. Now, undoubtedly, the government would have appealed to a higher court. And the Ninth U.S. Circuit Court of Appeals may well have ruled that this was a political question and that Judge White was wrong in claiming jurisdiction. But I think it was up to Judge White to rule that he did have jurisdiction. And then when the government appealed, I think the right decision for the Circus Court of Appeals would have been to say, we do have jurisdiction in this case because treaty law is the law of the land. And if that had then gone to the Supreme Court of the United States, they might have reversed both the Circuit Court and Judge White. But that's the process. That's what should have happened. And the Supreme Court, of course, would certainly have said that this was a political question. But this to me seems irrational. If you're going to say that treaty law is the supreme law, of the land, then judges have to have jurisdiction to say that somebody violated this law and should be punished. Or somebody violated this law and should be enjoined to follow it. What we've done in our country in terms of the development, of our law, quite a lot of it has to do with custom. And what we have decided over a period of time to consider from the viewpoint, of custom. It's certainly custom to say that the courts don't have the right to concern themselves with international political questions. But it seems to me that contradicts the idea that treaty law is the law of the land here domestically. That's a contradiction in what we've decided to do. And someday that contradiction has to end. Someday, some judge with the necessary courage and will has to say, no, I do have jurisdiction. And he has to say further, if the Congress meant for me to not have jurisdiction in this case, then it could have included in the treaty a prohibition for the courts of the United States to review this treaty law. Congress was free to have put this into the treaty, to have said, no, the United States will not sign this treaty until this exceptions clause for the judiciary is in it. But that's not what Congress did with the Genocide Convention. What it did for the Genocide Convention was to accept the Genocide Convention and accept the obligations of the United States under the Genocide Convention. And the acceptance of the treaty made the treaty the supreme law, of the land. And the courts have to have a say when people are violating the supreme law, of the land, unless Congress, as specified by the Constitution, specifically prohibits that they don't have jurisdiction. Congress does have jurisdiction, does have the power to specify jurisdiction of the courts. And if it did not do so, the assumption then is that Congress had no intention to limit the jurisdiction of the courts. And that's another reason why I say Justice White and his court, Judge White and his court, did have jurisdiction over this case. And he should have decided in favor of the plaintiff. Okay, going on to the second of our pieces for tonight. Well, let's hope I can get through that one faster. This was the Pennsylvania Supreme Court. This was a very, very interesting case. By the way, I should check in with you folks now and see what's going on here. We have Kay here and Steve Wolfbrand. Steve says hello, Doc. And Steve Ghost Steve Gostart says, or Steve GII says, the Biden administration just literally just blew up all the weapons of the Iraqi brigade that was fighting ISIS. Oh, God. That is so ridiculous. I can't believe it. Okay, anyway, those are the comments so far. So I'm going to go back to this piece so we get on with things. This is from Slate. And it's by Dahlia Lithwick, who's one of my favorite authors on judicial matters, and Mark Joseph Stern. And the state Supreme Court just issued the most devastating rebuke of Dobbs yet. And this was done on January 30th, 2024 at 5:14 p.m. And here's a picture of people saying, "My body, my choice, abort the court, stay out of my womb. Fitzpatrick is a forced birth extremist. Firebrian.com." And another sign says, "I marched because someone long ago marched for me." And another sign says, "Defend choice." Activists protest during a Bans Off Our Bodies rally in support of abortion rights in Doylestown, Pennsylvania on September 29, 2022. The Supreme Court's eradication of the constitutional right to abortion in 2022, Dobbs versus Jackson Women's Health Organization, had an immediate and devastating impact on gender equality in the United States. With a single ruling, 5 justices, and I have to add, okay, including, well, I don't know whether Amy Coney Barrett was actually part of this ruling, so I don't really recall, so I shouldn't say. With a single ruling, 5 justices wiped out millions of women's access to basic health care and handed control over their medical decisions to politicians and judges. It wasn't just the court's judgment, though, that relegated women to a lesser place in the constitutional order. It was also the court's reasoning, which used the centuries-long oppression of women to justify an ongoing oppression of women by way of a deprivation of their rights. Judge Samuel Alito's majority opinion rested largely on the views of dead white men who condoned the rape, beating, and murder of women to maintain female subjugation in every realm of life, and he dismissed his ruling's ruinous impact on gender equality in a single conclusory paragraph, asserting that abortion restrictions could not possibly discriminate against women. You know what I think about Judge Samuel Alito, of course. You know I think he is a crazy man. This week, the Pennsylvania Supreme Court responded to that conclusion. No. On Monday, the court issued a landmark opinion declaring that abortion restrictions do amount to sex-based discrimination and therefore are, quote, presumptively unconstitutional, unquote, under the state constitution's Equal Rights Amendment. The majority vehemently rejected Dobbs' history-only analysis, noting that until recently, quote, those interpreting the law, unquote, saw women, quote again, as not only having fewer legal rights than men, but also as lesser human beings by design, unquote. Justice David Wecht went even further. In an extraordinary concurrence, the justice recounted the historical use of abortion bans to repress women, condemned Alito's error-ridden analysis and repudiated the, quote, antiquated and misogynistic notion that a woman has no say over what happens to her own body, unquote. The Pennsylvania Supreme Court's decision thus spurned Dobbs in two ways. First, the majority held that laws regulating a woman's body do discriminate on the basis of sex, a truth that has been widely understood by legal scholars for decades. Second, the majority explained that rooting women's rights in the past is itself a form of sex discrimination, perpetuating misogynistic beliefs about gender inequality by judicial decree. As it was leaked and then published with almost no corrections to its myriad errors, Dobbs set off a firestorm of real-time criticism within the public, the legal academy, and the media, and that criticism is now finally returning to the courts in the form of decisions that both defy and rebuke Dobbs' chauvinistic logic. Monday's ruling in Allegheny Reproductive Health Center versus Pennsylvania Department of Human Services involves a challenge to the Pennsylvania law that generally prohibits the use of state Medicaid funds to cover abortion. The plaintiffs, a group of healthcare providers represented by the Women's Law Project and Planned Parenthood, focused on the Pennsylvania Constitution's Equal Rights Amendment, which was adopted in 1971, which bars the denial or abridgment of, quote, equality of rights, unquote, because of, quote, the sex of the individual, unquote. Laws limiting access to abortion, the plaintiffs claim, abridge this right of sex equality because they have a near exclusive impact on women. While transgender men can also become pregnant, the plaintiffs noted that pregnancy requires reproductive organs, typically classified as female, and most pregnant people identify as women. In an opinion by Justice Christine Donahue, the Pennsylvania Supreme Court agreed, quote, to treat a woman differently based on a characteristic unique to her sex, unquote, Donahue explained, quote, is to treat her differently because of her sex, which triggers enforcement of our Equal Rights Amendment, unquote. Again, the Equal Rights Amendment, that's the Pennsylvania Equal Rights Amendment. The ability to become pregnant and obtain an abortion is, quote, unique to one sex, unquote. By definition, then, any abortion restriction, quote, withholds or diminishes the scope, unquote, of women's rights, allowing them less freedom to make medical decisions than men. So, under the Equal Rights Amendment, these restrictions are unconstitutional unless the state can prove that they are narrowly tailored to promote a compelling government interest. Any other conclusion, Donahue noted, would disrespect the amendment's intention to create a sharp break from the past. It's true that for most of its history, Pennsylvania banned abortion. This regime, though, was part of a broader, quote, unequal treatment of women under the law, unquote, a treatment endorsed by the same misogynistic authorities Alito lifted up in Dobbs. Pennsylvania's Equal Rights Amendment was adopted with the intent to abolish this, quote, persistent relegation of women to subservient and dependent roles, Donahue wrote. And handing the state a blank check to limit abortion access would contradict this purpose. The majority sent the case back down to a lower court to apply the new standard rather than formally declaring the Medicaid ban unconstitutional. But the writing is on the wall. In his concurrence, West explicitly linked Donahue's equality-based arguments to Dobbs' flaws. quote, we cannot examine particular laws in their historical context without also examining the society in which those laws are developed, unquote, he wrote. And quote again, quote, the Dobbs majority relied upon the patriarchal notions of eminent authorities of Old English common law, including Lord Matthew Hale, unquote, whose, quote again, beliefs were driven by his goal of keeping women from encroaching upon the rights of men, unquote. Hale, quote again, who presided over the hanging of two women accused of being witches, unquote, thought that giving women, quote, legally enforceable rights over their own bodies was a threat to the freedom of men, unquote. He also insisted that marital rape, quote, was never a crime because marriage amounted to the wife's, but not the husband's, irrevocable consent to sex, unquote. Many of Hale's views aligned with those of William Blackstone, another historical key player in Alito's Dobbs analysis, who believed that, quote, a married woman had no individual rights of her own, unquote. Wecht went on, quote, here's a quote from Wecht, extended. The history represented by Hale and Blackstone is not, as the Dobbs majority seemed to believe, a neutral survey of history. It was the continuation of centuries of misogyny and oppression that our society has since rejected. The historical limitations upon reproductive freedom that the Dobbs majority found reveal the perpetuation of the subjugation of women throughout time, just as today's abortion restrictions reveal the present unequal treatment of women. Drawing on the work of uh, Melissa Murray, Reva Siegel, Aaron Tang, Kiara Bridges, and other leading scholars of reproductive rights, not one of whom is a dead white man, Wecht uh, um, 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 has meticulously corrected other aspects of Alito's profoundly flawed historical account. For instance, the Dobbs majority ignored the fact that abortion was widely legal at the founding of the Republic, at least in early pregnancy. It also ignored the fact that the push to criminalize abortion arose only in the mid 19th century, driven largely by a sexist Victorian impulse to keep women in the home, as well as a racist desire to, quote, prevent the white native born birth rate from being overwhelmed, unquote, by immigrants and racial minorities, quote. In disregarding this history, the Dobbs majority dismissed the reality that women lived in the mid 1800s, unquote. Wecht concluded. It's failure to look, quote again, critically at the misogyny that prevailed at the time, unquote, seems, quote again, designed to perpetuate the wrongs of our past, unquote. It was once widely conceded in the legal academy that we are all, as Justice Elena Kagan once quipped, okay, originalists now. But in the new, quote, now, unquote, we are beginning to see judges push back against the most crab and noxious methodologies of originalism, which hold that robed lawyers make for better historians than actual historians, or that it is somehow uninteresting or unimportant when the original meaning of the law replaces the subordination inflicted by its authors. Judges across the country are beginning to apply contemporary scholarship and renew recent understandings of the entire limiting project of relying exclusively on so-called history and tradition as meaningful barometers for modern freedoms. And in the process, they are discovering and explaining to laymen the inherent injustice of so-called originalist outcomes as delineating the bounds of equality and dignity for all. Okay, the lesson to be gleaned from the Pennsylvania Supreme Court's rejection of both Dobbs's cramped form and methodology and tragic result is not merely that state constitutions will be more essential than ever to protect against the misogynist and revanchist efforts to restore women to subordinate and indeed powerless vessels. That we already knew. The lesson is also that the conservative project of gluing a misshapen cutout of the past into a blank canvas of the present is itself an exercise in perpetuating inequality. This is as it was expressly designed to be. So long as judges are capable of independent thought, they will continue to call BS on the very notion that Dobbs's style, originalism, holds any real utility in ordering a complex, pluralistic, multiracial modern society. If constitutional values like equality are to endure, they will do so in spite of a structurally oppressive history and not because of it. Well, folks, I think that was a magnificent post, and I really have nothing to add to that post. Nothing at all to add to that post. The only thing I would wish is that some of the justices that wrote this particular decision are elevated to the Supreme Court very soon so that they can outvote the current group of schmucks that we see on the current court. I hope you'll excuse the Jewish expression in this context. Oh, there's Lisa. Hello, Lisa. I hope you liked the commentary and analysis that I just did on the Pennsylvania decision. That I think maybe you arrived a little too late for that. But you'll be able to view it since it will be on video. I'm going to share the screen again for the next particular decision, which I thought was also very, very interesting. This came from the Oregon Supreme Court, and it was recorded in an article by Common Dreams, which you should be seeing at this point. Piece from Common Dreams. The photo shows the empty floor of the Oregon State Senate. This was because many of the Republicans decided to stay home. The Oregon Supreme Court bans from the ballot, bans from the ballot, GOP state lawmakers who staged, a walkout. And the tagline is, Oregonians deserve legislators who will show up and do their jobs, and when they don't, there must be consequences, unquote, said one advocacy group. This piece was by Brett Wilkins on February 1st, 2024. Oregon Supreme Court on Thursday disqualified 10 state senators from re-election for participating in last year's Republican-led walkout. It paralyzed the legislature for 6 weeks, delaying the key Democratic bills on abortion, health care, and gun control. The ruling upholds last year's decision by Oregon Secretary of State LaVon Griffin. I guess her last name is Valade, or Valade, a Democrat, barring the 10 lawmakers, 9 Republicans, and 1 independent from the 2024 ballot because they had accumulated more than 10 unexcused absences in violation of Measure 113, a state constitutional amendment approved by 68% of voters in 2022, following a series of Republican walkouts. So this really isn't, seems to me, too questionable what they did. There was a constitutional amendment approved by 68% of the voters, okay, allowing the barring of state senators but from the ballot if they had more than 10 unexcused absences. So this was based on a part of the state constitution. That's the important thing to understand. Quote, I've said from the beginning my intention was to support the will of the people, Griffin Valade said in a statement Thursday. And quote again, it was clear to me voters intended for legislators with a certain number of absences in a legislative session to be immediately disqualified from seeking re-election. I'm not going to read everything here. You have the essence of it. Okay, right now, 5 of the sanctioned lawmakers challenged by Griffin Valade's interpretation of Measure 113's language, stating the lawmaker who misses 10 or more sessions is banned from running in, quote, the term following the election after the member's current term is completed, unquote. As the Associated Press explained, a debate was over when that ineligibility kicks in. If the senator's term ends in January 2025, they would typically seek re-election in November 2024. The quote election after the member's current term is completed would not be until November 2028, the Republican senators argue, so they could run for re-election this year and then hold office for another term before becoming ineligible. The court but disagreed, saying while the language of the amendment was ambiguous, the information provided to voters in the ballot title and explanatory statement made clear the intent was to bar truant lawmakers from holding office in the next term. Quote, if we were required to choose between petitioners and the Secretary's interpretations based on the text alone, petitioners would have a strong argument that their reading is the better one, unquote, the court's opinion states. Quote, but we do not review the text and avoid, unquote, the ruling adds. Quote, we instead seek to understand how voters would have understood the text in the light of the other materials, okay, that accompanied it, and those of other materials expressly and uniformly inform voters that the amendment would apply to legislators' immediate next terms of office, indicating that the voters so understood and intended that meaning, unquote. So that's the argument against it. That's the counter argument, okay, against it. And so I'll go on here. Quote, it is critical to our democracy that elected officials uphold the will of voters, not disrupt our constitutional rights or halt the democratic process when it does not align with their personal beliefs, unquote. The ACLU of Oregon said in response to Thursday's ruling. The Oregon League of Conservation voters said on social media that, quote, Oregonians deserve legislators who will show up and do their jobs. And when they don't, there must be consequences, unquote. Quote, voters were clear when they overwhelmingly passed Measure 113, and we're glad the Oregon Supreme Court agrees, unquote. The Green Group added. So, that's really pretty clear what happened and the basis, okay, on which it happened. Okay, I personally think, okay, it's a good thing. It's very likely that there won't be, following the 2024 election, there won't be 10 state senators who will be delaying the passage of bills on abortion, health care, okay, on gun control, and on green measures as well. So I think that's a very good thing, and I applaud okay, the decision of the Oregon State Supreme Court. So good news out of 2 state courts, Pennsylvania and Oregon. That's really great. Okay, and here's the final piece for tonight. And Lisa says, hi, Joe, I need to go back and watch. I just got here. And she says, yes. Oh, you would have loved that Pennsylvania Supreme Court decision. Yeah. When you read that, it's going to do your heart good and your soul too. really, really do you good. That was just a wonderful, wonderful decision. And the write up by Dahlia Lithwick and Mark Joseph Stern was beautiful, just beautiful. So you're going to love that. And I think you're probably going to like the first article, too, here, which is about the Center for Constitutional Rights case, okay, in Gaza. And you'll probably like my criticism of the finding of the trial judge, okay, as well. Anyway, going on, she says, I need that right now. Yeah. Okay. Now I'm going to go to Bob Reich. And this is really the only thing which, at this point, expressly relates, okay, to dump the corruption. But here we go. So this is another Common Dreams article. There's House Budget Committee Chair Jody Arrington, Republican of Texas, right? And Speaker of the House Mike Johnson, who's Republican of Louisiana, on the left. He's a guy with glasses. Are seen during a meeting of the House Republican Conference in the U.S. Capitol on Tuesday, November 14th, 2023. What if lawless GOP lawmakers in the House refuse to certify the 2024 election, unquote? Of course, they're talking about the presidential election here. This is what it looks like if Trump loses at the ballot box, but Republicans do next time what enough of them refused to do last time. This is February 2nd, 2024. It's from Bob Reich's Substack. It was picked up by Common Dreams. I worry that those of us who are dedicated to democracy and therefore committed to playing by the rules are underestimating the willingness of House Republicans to break the rules to elect Trump. Excuse me for 1 second. I have some pills to take. Bonnie is smiling at me because I take these pills. So, remember, most current Republican members of the House, including Speaker Michael Johnson, refused to certify the outcome of the 2020 election. In fact, Johnson helped organize 138 Republican House members to dispute that outcome, despite state certifications and the nearly unanimous rulings from state and federal courts that it was an honest election. If Johnson and his cronies had so few scruples then, why should we assume they'll have more scruples in the weeks following November's elections? What happens if, in the wake of the elections, the House's election-denying Republicans find that they can retain their majority in the next Congress only by denying certification of Democratic candidates who have won by close margins and do so? I have to say I'm not sure that Bob is right here, because if you recall, the certification of the presidential elections happens in the new Congress. Of course, in 2021, it happened on January 6th, after the new Congress had taken its place, both the House and the Senate. They had convened on January 3rd. The same will happen in 2025. So the certification of the presidential election occurs in 2025. And I'll emphasize the significance of this a little later. As Reich says in the next paragraph, then on January 6, 2025, what if the new Republican majority refuses to certify as president any electoral college results from states that went for Biden by close margins thereby ensuring that no candidate receives an electoral college majority. Well, okay, that's an interesting if, but it assumes there's going to be a new Republican majority in the House. As far as I know, there's no certification process that goes on at the federal level uh, for new people who have come to Congress and take their seats, okay, on January 3rd. The old Congress has no influence on that. So, if people see to it that there is not, okay, a Republican majority on January 6th of 2025, and if a Democrat or a Green or some other third party candidate happens to win, okay, the presidency, there shouldn't be a problem, okay, of certification. But going further, presto, says Bob. Okay, the decision about who's to be the next president is made on a state by state delegation vote, almost surely delivering it to Trump. But again, Bob is tacitly assuming here that there will be a new Republican majority. Okay, not necessarily true. Is this scenario really so far-fetched? No, there could be, a new Republican majority. Two astute Washington veterans conclude in a recent article in the Washington Spectator that it's not at all far-fetched because, quote, good faith can no longer be assumed, unquote. I agree with that. Good faith can no longer be assumed when you're dealing with the members of what can only be described as a fascist party. I'm afraid our Republican Party over time has become a fascist party that wants to end the republic as we know it. Long before we reached this constitutional crisis, Speaker Johnson and others in the Republican House leadership must pledge to certify the results of the November elections. Well, I'm not sure how effective that's going to be, Bob, because even if they do pledge to certify the results, of the November elections, that might be counterproductive because then there might be a Republican majority, in the House. And if there is, a Republican majority in the House, then they might go back on their pledge on January 6th of 2025, because that's what fascists do. Going on, I don't think a pledge by them is going to be, of any use. What has to be done is to ensure that they do not win a majority, in the House. They should be asked by the media to make this commitment. If they won't, Americans need to know, and know why. Well, it might be a good idea actually to ask them to make this commitment. After all, because if they won't make the commitment, then we'll know why. In other words, if they're not going to make it, then there's a clear intention that they're not going to vote to certify the result, of the November elections. On the other hand, if they do make the commitment, I'm still not sure that they're not going to vote not to certify. So it's worth noting in this regard that Representative Elise Stefanik, the fourth-ranking Republican, in the House, recently refused to commit to certifying the result of the 2024 elections, saying, quote, "We will see if this is a legal and valid election," unquote. Of course, that's a Donald Trump tactic. We will see if this is a legal, and valid election. She then claimed that the 2020 presidential race, quote, "was not a fair election," unquote, despite multiple legal reviews sought by Trump and his allies confirming that it was. And Bob asked the question, why hasn't this been more widely reported? Well, the reason is probably because uh, our mainstream media are so incompetent. That would be my explanation for it, because they're certainly not all that pro-Trump. So you would think that they would report on this. I would think they report on this. But I have to bring up the main issue which is raised by this article, and that is, how do we ensure that these Republicans will not be in the House? Of course, you could decide to vote against every Republican just on grounds that they are Republicans. But I think a much more effective way to vote, okay, is according to the rule. We know all the, from surveys of Congress people that we've already done that it's unlikely that any Republican will not be taking big money. It's also unlikely that any Democrat will not be taking big money. So if everybody votes according to the dump the corruption rule, okay, then the result will be that all these people who may not vote to certify, okay, a fair election, won't be in a position to vote again on that question. That would be, okay, a wonderful thing. But it would also be a wonderful thing if all the Democrats and all the independents who are taking big money from many sources, uh, okay, are thereby also kicked out of any possibility, okay, of office. So that's my dump the corruption message for today. Okay, I also have an announcement to make that I made as well last night, and I want to make it again, okay, tonight. Starting next week, I'm no longer going to be doing these long shows, okay, any longer. Uh, okay, the attendance that I'm getting for these shows, I love these long shows, I have to say it. Okay, I love to do them. They fit with my personality, and I just love to go into depth. I love to read the articles. I love to criticize them, as I go along. So I love this style, okay, of show. But from an economic point of view, it's not really practical for me. I've stuck with it now for years and years and years. And there are just too few people who come. So I'm going to give in to what I think is the prevailing trend in streams right now. And that is for shorter streams. So starting Tuesday, okay, next week, I'm going to be aiming to do, under the title of Empowering Democracy, sometimes also Dump the Corruption, I'm going to be aiming to do 3 shorter streams per day between Tuesday and Friday instead, okay, of longer streams. Specifically, I'll be aiming for streams that last between 15 minutes, okay, and half an hour. I'll be aiming to do 3 of those streams per day, as and when I encounter things that are worth commenting on, okay, or talking about. So there will be a new style of stream going on that has, okay, a number of advantages for me. I hope you'll still come to those streams, but they're not going to be at regular times. So, uh, okay, if you come, okay, on YouTube, uh, okay, you'll have to click, okay, the bell frequently to ensure that you are notified, okay, of those streams. They'll probably be coming up with no more than, I don't know, uh, just a few minutes of notice, I guess. So, okay, anyway, okay, I hope you'll watch for them. I will tweet first that I'm going to have a stream. So that will give you, okay, a few minutes notice, and then the stream, okay, will go on. Okay, that's the way I'm going to handle it from now on. Okay, I hope you like it. I hope it's convenient, okay, for all of you. I'm going to try it anyway and see how it goes. As I said, these streams will be going on from Tuesday through Friday. I'm still going to appear on D shows which occur. Okay, uh, the show, okay, Around the World with D and Friends, okay, occurs generally, okay, at 8 o'clock. But since I'm not now scheduling my shows for 9 o'clock, it's quite possible that Dee will take the opportunity to take the 9 o'clock slot herself. Anyway, whenever Dee has a show, okay, Around the World, okay, with Dee and Friends, if those shows go on from Tuesday through Friday or Saturday, I will also be participating in those shows, which, as you know, okay, are international relations um, um, shows. I should also say, also Lisa says, please do Blue Sky as well. Okay, I will do Blue Sky. Okay, as well, Lisa. I promise. Okay, and also, okay, I should add that I've really enjoyed the international relations shows, okay, that I've done. So a lot of these short shows are going to be, on international relations also. I have so much to talk about there. Okay, as many of you know, uh, during my PhD years, I was specializing in comparative politics, okay, and international relations. And when I first started my career, my specialization was in peace research and in conflict studies, and was mostly focused, on international relations. Okay, and so uh, Lisa says that she loves these shows, and she also says, "I'm going to admit I am a bit sad about this." Uh, and Kay says, "Yes, me too, Lisa." Well, I'll try it. I'll see how it works. Okay, I'm very flexible on this. Okay, there may be a mix also. Okay, it may turn out that uh, there'll be something like, one long show per week, and then 3 shows a day. When I'm not doing, okay, a long show. Okay, so I'm going to mix it up until I find the formula that works best. Okay, with respect to attendance, but I really can't afford, okay, to continue doing these long shows where I have only 4 or 5 people, okay, who attend. Uh, that's not really practical, okay, in this particular niche. Okay, it's it's just not practical. It doesn't work. I've resisted the question of impracticality here. I've been aware of it. Okay, but I've resisted it for years because I love these shows so much. But I can't resist it anymore. Okay, I have to make change. So Lisa says, I like that idea, Joe. Do one long one a week. Okay, I'll tell you what. I'll do one long one a week. I'll probably do the long one on international relations. Well, I guess I won't really commit to that. What I will commit to is the long show will be on Tuesday night. How's that? So the long show will be on Tuesday night, and the short shows will be on Wednesday, Thursday, okay, and Friday. So what's the consensus on that? Please comment, folks. Lisa says yes, and she says, come on, commit. Okays. Okay, so I'll do a long show on Tuesday night. Unless there's something special, it's probably going to be an international relations show. And I'll do short shows, okay, for the rest of the week. Starting next week, okay, on Tuesday night. And after all this, Lisa, I expect you to be there on Tuesday night. Okay, so I think that about does it for tonight, unless there are more comments. Okay, or questions. Okay, I have another alternative also. I could continue to do these long shows if I could find, a volunteer, who could do the video editing that I need to break these long shows, into parts. For example, this show could easily have been broken into 4 shorter videos. And I would have been happy to have the long video. I would have been happy to keep, the long videos and have them broken up into 2 or 3 or 4 shorter videos. I mean, I could have gone with that, but I don't have anybody to call on to do the video editing for me. And I just don't want to take the time to learn, the video editing myself. So that is part of the motivation of going to short shows. So Lisa says, video editor needed. Okay. So that's the situation right now. I'll probably see you all tomorrow night. I'm pretty sure Dee's going to have a show tomorrow night. It'll probably be at 9 p.m. because her Saturday shows, are at 9 p.m. And I'll be there for that show. So please do come to that show and come to all my shows, next week. If things go as I hope they will, right now, I will have something like 10 shows next week. I think that will be pretty good. I'll be flooding the airwaves. I think on that note, I'm going to say goodnight. And Lisa says, love to all. And love to you, Lisa, as well. Love to you, Kay. Okay, love to you, Steve, if you're still here. As well to Steve GII, also known as Steve Ghost Start, and Steve Gonzo. Anyway, I think that's it for now. So.